In Canada, disagreements over energy or environmental law and policy are often mired in jurisdictional disputes. Provinces insist that energy and resource development are matters falling squarely within their wheelhouses, while the federal government often maintains that it has an important role to play in environmental protection and pollution prevention, including with respect to climate change. So, who is right? While each law or regulation has to be assessed on its own merits, the answer always lies in that part of Canada's Constitution that divides legislative powers, the power to make laws, between the federal and provincial governments. This is what lawyers and judges call the division of powers. Where energy, the environment, and natural resources are concerned, the most important sections of the Constitution are 91, 92, and 92A. Section 91 states that Parliament may make laws for the peace, order, and good government of Canada, and then goes on to list 29 specific classes of subjects that Parliament may make laws in relation to. These include taxation, navigation and shipping, and seacoast and inland fisheries, to name but a few. While Section 92, meanwhile, sets out the classes of subjects that provincial legislatures can make laws in relation to. These include the management of public lands, property and civil rights, and local works and undertakings. Amendments to the Constitution in 1982 saw the addition of Section 92A, which expanded the classes of subjects set out in Section 92. Now, provincial legislatures have more explicit authority to make laws in relation to the development and management of non-renewable natural resources and forestry resources, and the development, conservation, and management of sites and facilities for the generation and production of electrical energy. In part 2 of this video, we'll discuss how courts approach these lists and how they sometimes overlap. Importantly, each class of subject has been interpreted and reinterpreted by Canadian courts over decades. So when lawyers and judges assess whether a law or regulation fits under one class of subjects or another, they don't start with a blank slate. They apply existing interpretations. The other critical thing to remember is that many real-life problems and policy challenges don't fall neatly into just one class of subjects, whether federal or provincial. Consequently, Canadian courts have recognized that many problems and challenges will have both a federal aspect and a provincial aspect. This legal doctrine is known as the double aspects doctrine. So for example, the regulation of mining generally falls under provincial jurisdiction over non-renewable natural resources under Section 92A. But because mining effluent may impact fish-bearing waters, federal jurisdiction over inland fisheries is also triggered. In the environmental context, overlapping jurisdiction is the rule, not the exception. The most important current case to watch is the Supreme Court's pending decision in reference regarding Impact Assessment Act, where Alberta has argued that the federal impact assessment regime is unconstitutional. The outcome of that case very much depends on the court's approach to the Constitution's division of powers.